Kavanaugh?
Just want to follow up there and ask about one thing in your brief. On page 32 of your brief, you deal with a few hypotheticals. The hypotheticals you dealt with were requiring Muslim filmmakers to promote Scientology, compelling lesbian artists to design church websites criticizing same-sex marriage, or, and the third one I really want to focus on, or forcing writers to write speeches that violate their most deeply held convictions. So those are the three hypotheticals you posit, responding to the other side. And then you say, those hypotheticals, unlike this case, involve direct burdens on speech because they contemplate speakers being forced to create and convey ideological messages they would not create for anyone. And I think the other side would say, that's exactly this case, too, to take that third category. These are writers, in essence, being asked to write speeches that violate their most deeply held convictions. So I'm trying to figure out, given what you say there, how you would say this case does not involve the same thing as a writer being forced to write speeches that violate their most deeply held convictions.
Because in each of those hypotheticals, you can't posit a content-neutral law like a public accommodations law that would validly require the writer or the speaker or the filmmaker to do what the hypotheticals posited. It's because in those cases, as we say, it's a direct burden on speech. The regulation is compelling you to write something you deeply disagree with because of the message. It's not incidental to a content-neutral regulation of conduct like the court confronted in Fair and like we believe it's confronted with here.
You don't think applying a public accommodations law to a speech writing business that offers to do speeches or PR releases for anyone, but they say, oh, we're not going to do this message. You don't think that's this? They would say that's this case, and you say it's not because?
I think they'd be wrong. So first of all, at a couple of levels, speechwriters aren't likely to be public accommodations. Set that aside. Suppose you had one that was one, right?
Until they are, after this case, if you prevail, I mean, that's what states could do.
But I've tried to give you, in response to Justice Alito, there is, I think, a constitutional backstop about, core public accommodations laws we think satisfy O'Brien's scrutiny. If a state wanders from that, not so much. But again, just to get to the nub of your hypothetical, we think if the speechwriter says, here's a speech that expresses views that I abhor and I won't write the speech, they wouldn't do that for anybody, regardless of status. Now, it may be that the status of the person who's asking them to write the speech is somehow correlated with the message in some way, but that's still not status-based discrimination in the way that the law regards discrimination against people who are entering into a same-sex marriage as status-based discrimination.
Okay, thank you.